Your Honor, I had filed the notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently. And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right, you can call Ms. Tubbs' case.
Okay. Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes, Your Honor.
Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says, at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No medication.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right. And I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What date?
March 17th.
Okay. So this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed the notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly, willingly, and intelligently. And I would like to.
Right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, if once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm going to have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not going to do it, but I just want you to talk with him and understand some of the risks of doing this. And okay?
Your Honor, I understand all the risks and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're going to need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I'm here to reserve my right.
Let's have you raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then, ma'am, I'm not going to have you self-represent you until you do this. So if you're not going to do it, we're going to continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any. We're not.
But I need to know what
oath
am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right. Well, let's have her raise her hand again, and you say the affirmation. It's not an oath. It's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No. Yeah. Okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right. Thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
Well, I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
punishable up to 5 years. or
It's-
fine not?
Ma'am, just wait. Let me speak, okay?
I'm
Madam
sorry.
It would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender, second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's not what the
Oh.
the elements of the offense are.
The elements. What do you mean
Yeah.
by elements? Because you know y'all
Well,
use double language.
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is that, yes, that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
So
no,
what?
you don't get to quiz me. Ma'am, what do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have
be
you
able to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No. Do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes,
Did you know that the first day of law school, they tell us that he who represents himself has a fool for client? Do you know they tell us that?
yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
You know what it tells me?
Yeah,
That
what's
you
that tell you?
You all operate in trade secret acts. So
Okay.
it
Well,
would be a
that's not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes,
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
yes,
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made
correct.
and accurately and understandably?
Yes,
Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report
Can you
and the
get her
oath of
whatever
office,
discovery
please,
you
so I
have?
can know what I'm dealing with.
All right.
Do you guys
You'll
just go
send-
by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm not advising you on the law. I told you I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yeah, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right, well, go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay? We will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
Your Honor,
You need to send all the materials to her. And also, if we can get her brought here from the jail, Madam Clerk. Okay,
that's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Miss Tubbs would be here, where we would all be on the same page.
well, we're gonna get the standby and do that right away as soon as we get that.
Okay.
I
We can
request
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt. All
excuse
right,
me.
we'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk. Okay, is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath. you are requesting that there not be an insanity defense. Is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me. Prepare an order that says that she's withdrawing any insanity defense. Okay? All right. What, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock. All right?
Thank you.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
Good morning, Judge Deanne Patillo, P82378 on behalf of Ms. Tanaya Tubbs.
Ms. Tubbs, can you unmute and state your name for the record, please? And is Ms. Patillo standby counsel? Is that what this is?
Yes, Your Honor.
Okay. Ms. Tubbs, if you can state your name for the record, please.
Grand Rising, I asked the Holy Spirit to come in here and touch this courtroom today, and I welcome the Holy Spirit. I am Tanaya Nicole Tubbs, the beneficiary. Come in here.
Okay. And Ms. Patillo is being appointed as your standby counsel, Ms. Tubbs, all right?
No, sir, I did not ask for that, but if I'm being forced, then I'm being forced in direct coercion.
All right. Well, I'm not forcing you, but she's going to help in case you need anything. You don't ever have to use her, but if you want any questions on anything, she's there to help you, okay? You're gonna represent yourself, but if you have any questions, you can ask her, all right?
I hear you, sir.
All right. Do we have a jury trial date on this?
March 17th.
All right. We'll set this is set for jury trial on March 17th at 9 a.m. Ms. Tubbs, did you want to discuss settlement with the prosecutor, or do you just want to go ahead to jury trial?
I wanted to ask the prosecutor a few things, if you don't mind.
Okay.
Your Honor, one of the things I think that we put on the record last week when we were trying to establish whether Ms. Tubbs was going to represent herself, if we were going to relieve the prior defense counsel of his obligations and then also get standby counsel. And I think that today was more of an update just to make sure everything was in order, but knowing that the trial
And I have ruled that she can represent herself, haven't I?
Yes.
Okay, all right.
And that's why the other counsel was relieved and
Right, okay.
Ms. Patillo was put on as standby.
All right.
With that, I think that we had mentioned the possibility of having Ms. Tubbs be brought over here so that we can have discussions. Ms. Patillo is standby. I feel comfortable speaking to Ms. Tubbs as long as there's somebody else there. Even if they're not fully representing her, at least there's a third person. And I wouldn't mind speaking to her in person, but I think it's going to be easier if she's here, and I don't necessarily want her to say something on Zoom in open court that might affect her case when she's representing herself.
All right. We can do this one of two ways. Either can put all of you in a breakout room and let the three of you discuss things, or we can bring her here.
I would ask Ms. Tubbs what she would like to do.
Ms. Tubbs, what do you want to do? Do you want to go into a breakout room with the standby counsel and and the prosecutor, or would you like to come here physically to talk with them?
I can do standby counsel. I mean, I can do not standby counsel, but I can talk to them in the break room since she's afraid of what I have to say, so the public would not hear.
So if I could interject, I apologize, Your Honor. Would I be able to, well, if Ms. Tubbs allows, would I be able to speak to her before she speaks to the
I don't allow.
That's an excellent idea. Ms. Tubbs, would you be willing to speak privately with Ms. Patillo?
No, sir.
All right. Ms. Patel, I don't think I can order her to do that. So, Ms. Tubbs, as I told you before, we got taught the first day of law school, he or she who represents themselves as a fool for a client. I would strongly recommend that you talk to Ms. Patella, but if you don't want to, you don't have to. What would you like to do with that?
With all due respect, sir, I am not working alone. I work with the Holy Spirit, so only a fool would think that the Holy Spirit ain't helping me. Not being smart.
All right, and I'm not being smart with you either. I'm telling you what they told us in law school, all right?
That's understandable.
All right, that's fine, Ms. Tubbs. So she apparently, will you be willing to have Ms. Patella in the room with you and the prosecutor?
Sir, I do not need her. Thank you.
I
All right.
I want somebody.
Yeah.
Regardless
so the
of who it
prosecutor
is.
says she does not feel comfortable talking directly with you without somebody else in the room. So
you're
you tell
forcing me. You're forcing
I'm
me
not
to have.
forcing you to do anything. You know, you don't have to talk to him. We can just go ahead and have a jury trial. That's fine with me. So what the prosecutor is saying is if she wants to talk alone with you, that there has to be somebody else in the courtroom or in the room. So you tell me.
She can have her in the courtroom, but not on my behalf. It can be on her behalf since she's fearing what I have to say alone. I'm not understanding why.
Put the three of you in a breakout room to discuss things.
Okay, thank you.
Do you agree to that, Ms. Tubb?
I agree to speak with her with the third party on her side.
All right. And counsel, how long do you think we should put you in the breakout room for?
10 minutes to be safe.
10 minutes, and then you can have more time if you need it, okay?
Okay,
I'll take 5 minutes.
Okay, well, I'm gonna put you in 10. You can always stop early, okay?
Thank you.
Is there anything else we need to take care of before we send you into the room with Ms. Tubbs? Is there any other matters that are ready? Madam Clerk?
Yes, we could take care of Mr. Kehoe.
Well, you know what? It's too complicated. Let's let them do this. Can you come into the breakout
Yeah, I'm gonna go into the conference room and log into Zoom.
Okay, all right.
People of the state of Michigan. People of the state of Michigan is the people on the benches. It's us versus us. This is sad. Oh, I pray we wake up.
Let's go back on the record with regard to Ms. Tubbs' case. All right, let's call Ms. Tubbs' case, please.
Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
And good morning, Judge Dion Patillo, P82378, standing counsel for Ms. Tanea Tubbs.
All right, Ms. Tubbs, if you can unmute and state your name for the record, please. All right, you can speak now. I think it's unmuted, ma'am. Yep, I can hear you. Yep.
For the record, I am Tanea Nicole Tubbs, the beneficiary of the account.
All right, Ms. Tubbs, you have a constitutional right to be physically present for this hearing. Do you agree to waive that right for today and hold this hearing by Zoom?
Correct.
Okay. All right. Where are we at on Ms. Tubbs' case, Madam Prosecutor?
Your Honor, I did get some information from Ms. Tubbs, and I did look up I know that the defendant is in Calhoun County Jail right now, and that she has a sentencing date of March 24th, 2025. When is our trial date? The 17th?
March 17th.
I'm guessing that Calhoun County would let her come here pending their sentence, since we have a trial date. I don't know how that all works because their case is a 2022 case, so it's definitely older. But either way, that's a problem for somebody else, I suppose. I think that Miss Tubbs needs to be brought over here and maybe we should have a pretrial before the trial once Ms. Tubbs is here, where we're all in person. And Ms. Tubbs can bring whatever documentation that she wishes to provide at that point. That way we all have it, and we're all on the same page, because some of the things that she's referring to, I do not have. And I would say that we're likely going to have to proceed to trial.
All right. When are you proposing that we have this, bring her over beforehand? Obviously, the closer to the date for the court's purposes, the better, because we don't have to retain her as long from Calhoun. But if you think it would help to bring her earlier, we can do that too.
I think that approximately 2 weeks before, so that puts us in the March 3rd area. Sometime at the end of the week before or early the week of March 3rd.
I'm available the 6th, if that works for the court, prosecutor and Ms. Tubbs.
All right, why don't we schedule this to have her brought over here for March the 6th, and we'll have the hearing at 11:30. Is that time okay for you, Attorney Patella?
Yes, Your Honor.
All right, we'll set this for March 6th at 11:30. Hey, May, can you send a writ to have her brought from Calhoun County here?
Yeah.
Okay, all right.
Excuse me, Your Honor.
Yes, go right ahead, Ms. Tubbs.
I am looking forward to being out of here before then. And it is my duty to come there on my own as a freeborn sovereign to this. I do not need to be detained or retained. I am not an entity or subject to any entity. And I gave this paperwork to the 36th district, and I'm not going to be able to get this paperwork if I don't be able to walk and go get it, go home and print it out myself, because I have none but 8 children. I am by myself. I don't have support. I just have myself and my 8 children, which my oldest just went to prison, so he's not able to help me any longer.
All right, well, we'll see you on March 6th at 11:30. You have a nice day, ma'am, okay?
So there is no holds on me, correct?
Well, you're going to be in the jail here, Wayne County Jail.
What I'm telling you is that I'm going to be released from here either today, tomorrow, and I do not need any holds to come to another jail. I am a freeborn sovereign. I do not need to be detained or retained. I am not subject to any entity, or am I entity. I am a living being.
All right, you have a nice day, ma'am.
Michigan versus Tanea Nicole Tubbs. This matter is scheduled for a pretrial appearance before the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P 78815.
Good morning, Judge Dion Patillo, P 82378, appearing as standing counsel for Ms. Tanea Tubbs. Can you state your
Ms.
name?
Tubbs, could you state your name for the record?
Grand Rising, I would like to welcome the Holy Spirit in here. I would like to thank the Holy Spirit, and I would like to bring peace, joy, justice to this courtroom, as well as liberty. My name is, I am the beneficiary, the principal and equitable title holder, Tanea Nicole Tubbs, beneficiary.
All right. Ms. Tubbs, the person that's standing next to you is your by attorney. You can ask her any questions at any point in time. You're going to be representing yourself, but she will be here to answer any of your questions. Did you want an opportunity before we get going here to talk with her? Would you like to talk privately with her before we get started?
At this time, I would like to, I could talk to her for a second.
All right. Why don't we just send her back there? And then I don't know if you're going to have any, as the prosecutor, if you had a chance to talk with the standby attorney, or how do you want to do that?
I wanted to talk to the prosecutor.
Right.
Yes.
So I'm going to send her back and let them talk. Then do you, the three of, how do you want to handle that, Madam Prosecutor? Once she's met with her attorney.
However, I don't know whatever the court prefers. I mean, I'm happy to talk with all three of us together.
I guess if any offers, you can just put it on the record in court, huh?
Yeah, and I think that before we even get to there was no offer in this case. They were waiting on a mitigation package, and obviously because of how the competency has gone and the new attorney, and then Miss Tubbs representing herself, like there was no mitigation package. I could obviously go and get an offer, but before going that far, I want to know, speaking with the defense counsel and Miss Tubbs, where.
Right. Why
If
don't
that's
you
even a
talk with
thing.
Miss Tubbs, kind of figure out what way you guys want to, what way she wants to go, and then we'll talk more,
I want to
okay?
dismiss this.
Okay, but well, you talk with your attorney, okay?
I'm not having an attorney.
I'm not your attorney, but your
Okay.
standby counsel.
Okay.
P 82378 on behalf or stand-in counsel for Miss Tanaya Tubbs.
Grand Rising, I would like to welcome the Holy Spirit into this place and thank the Holy Spirit to touch each and every last one of us, bringing joy, peace, liberty, and justice. I am the principal and equitable title holder, the beneficiary, Tanaya Nicole Tubbs, reserving all rights under UCC 1-207 and UCC 1-308.
All right, counsel, where are we at on this matter?
So what we discussed was, Ms. Tubbs stated that she didn't have all the discovery, so the prosecutor went and printed all of the discovery. In terms of digital discovery, since Ms. Tubbs will still be in the Wayne County Jail until the trial, I'll put it on a flash drive and
Okay,
take it to the jail.
okay.
She just would need a laptop.
All right, you want me to order a laptop for her?
Yes.
All right, then I'll order that Ms. Tubbs is to receive a laptop from the jail. All right, any other matters we need to take up?
The only thing I would like to indicate for the record, Judge, is that I am right now, the only thing that I didn't include in the discovery, I realized as I got down here that I didn't print the witness list. So I'm going to send that to the court and ask if Marita would be so kind to print just the copy of the witness list off. I will say that as far as paper discovery goes, I have included the felony information with all of the charges, the investigator's report, which is 3 pages, the reports from the police officers, which are 13 pages, the defendant's statement, which is a 3-page document, the Center for Forensic Psychiatry report that pertains to our case because we did not get any of the other ones from Calhoun County. The notice of insanity defense that the prior attorney, Attorney Glenn, had filed. And with regard to the preliminary exam, I did check, it was waived, bound over, so there is no
You
transcript.
requested that be terminated, correct? That
No.
request for insanity defense? You don't want it do you want it insanity defense?
No.
Okay.
I just wanted to make sure that I provided a copy of it.
I make sure we have an order that she has requested the withdrawal of an insanity defense. I think we already did that, but if we didn't, we need to sign that today.
Okay, and right now, your court clerk did print off the witness list for me. So I'm adding that on the discovery, and it is 1 page, Your Honor. And then I've put all of the discovery together, the paper discovery together in a white envelope that the defendant will be able to take back with her and have a physical copy for herself.
All right, can we give all of that to her right now?
Yes, I am.
I have a request.
Ms. Tubbs would like to address the court.
All right, Ms. Tubbs, you're receiving all that documentation, correct, ma'am?
And these are the.
Wait, no, we're
Yes.
we're gonna do
Yes,
this one
I'm
at a time.
receiving the
Ms.
discovery
Tubbs, have
package.
you received all the discovery she just said?
Everything but what she said, the witness list.
All right, it's my understanding you gave her the witness list too, correct, counsel?
Yes, I added the witness list.
Also the injured party.
It's in the discovery. You just gotta read.
All right, so you have the witness list. You agree to that, ma'am?
Yes.
And you have all the other discovery, correct?
As of what she gave me, yes.
Okay, what else, ma'am?
The digital, but I'm gonna provide that.
You're gonna provide that, okay, all right. Anything else?
Besides, I would like to approach the bench.
Well, you can speak from
I
there.
can speak from here.
Yeah,
All
okay.
right, thank you.
Yeah.
I'm asking for this, court to dismiss this case on behalf of the facts that this is a Nisi Prius courtroom. This also goes by equity, which also has no jurisdiction over me. I am not an entity, nor am I subject to an entity. And I have given all my rights that been infringed, which, this goes by the Constitution, correct? And this goes by equity, correct? So by that being said, my rights was infringed. I have the right to bear arms and I have the right to travel. And that's
Anything
why,
else? Yeah,
Uh,
your motion to dismiss case, anything else?
that's my motion to dismiss. You
Okay.
also gave, I gave you,
Well, is there anything else with your motion to dismiss? I need to rule on that once you're done.
yes.
Anything else on the motion to dismiss?
Yes,
Okay, go ahead, man.
my due process has been violated, right to
Okay.
life and liberty. The 180-day rule has been violated. There is no crime. If there is no injured party, I'm the only injured party. And that will be all. Besides, I reserve my rights, to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of a compelled benefit under any unrevealed contract of the commercial agreement.
Okay, anything else with regard to your motion to dismiss?
I'm just asking for a motion to dismiss.
Okay, there is absolutely no basis in law with regard to your motion to dismiss. I deny it. Anything else we need to take up, ma'am?
So the only other thing was the documents that we were speaking of when we were on Zoom. Ms. Tubbs did obtain those and she just wants me to give them to the prosecutor.
Okay, I have no idea what documents you're talking about, but
It's the bill of complaint and equity, presentment to void proceedings and jurisdiction.
And also my
Yeah.
affidavit of truth.
And yes.
It's on the other day. In my Cessna Q trust, because this is accordingly to.
I'm gonna need you to speak up, ma'am. It's a big room. Thank
Also,
you.
it's for my Cessna Q trust. I am the beneficiary over the trust account. You guys are acting as a.
Well, that really has
fiduciary,
nothing to
correct?
do with this courtroom,
It
but
really
anything
does.
else, ma'am?
It does,
Anything else?
but you can say that.
All
No,
right. Have you discussed potential resolution of this, Madam Prosecutor?
Your Honor, I have not talked to the Ms. Tubbs today, and the last I heard prior to her going off the record is that all she wants is the case dismissed. I don't know that there is a resolution that Ms. Tubbs would be amenable to. And the last time I spoke with her, when we were on Zoom, she indicated that the only thing she is seeking is a dismissal, which the people are
Well, I've
not.
denied that dismissal. We're scheduled for trial on March 17th. I don't accept pleas on the day of trial. Do you want to discuss resolving this matter with the prosecutor, or do you just want to come here March 17th at 9 o'clock for a jury
I
trial?
would like to discuss some resolutions.
All right.
The only thing that I can think of, Judge, in talking to your deputies is if the court wanted to turn.
You know, we're going to do this in here.
Okay, that's what I was going to say.
And I'm going to ask everybody to step out of the courtroom other than Ms. Tubbs, her attorney, and you.
Okay.
And I'm going to turn off Zoom and that type of thing, and then let you discuss that. But I'm going to ask everybody to please step out of the courtroom. And we'll reconvene once they're done discussing everything.
Case 2400390201, the people of the state of Michigan versus Janaea Nicole Tubbs. This matter is scheduled today for a pretrial. Appearances for the record.
Good afternoon, Your Honor. Elena Rozek on behalf of the people, P78815.
Good afternoon, Judge Dion Patillo, P82378, standby counsel for Ms. Tanaya Tubbs.
Great afternoon. Coming in as the principal and beneficial equitable title holder, Tanaya Nicole Tubbs, beneficiary, natural living being. Coming in UCC 1-207, UCC 1-308.
Counsel, where are we at on these matters?
Your Honor, I believe that this is going to go to trial on March 17th. We did have an opportunity once the court excused itself and gave the courtroom to us to review some of the digital discovery with the defendant. Not all of it. There is 5 different videos, 3 police officer body-worn cameras, 2 scout car videos. One of them is of the front of the scout car looking out. The other one would be for the back seat of the scout car. We have not gone through every single one of them, but we went through 2 different angles of body cams and that covered the incident that the defendant is charged for. She and I have a disagreement on what the actions were and what the facts are, and therefore that's what a jury trial is for.
Okay. Can you put on the record what the offer is, what the sentencing guidelines call for, and what you're going to recommend as far as the sentence, just so Ms. Tubbs understands everything?
Let me just double check really fast.
Okay.
It's long.
She said she's not in. On Zoom.
Oh, I see. That's.
Okay, Your Honor, with the guidelines, 35. The guidelines as charged, if the defendant were convicted of 1 count of carrying concealed weapon, 1 and 2 counts of resisting and obstructing a police officer, and the habitual second offense notice, the guidelines would be 7 to 28 months to a maximum of 7.5 years.
Is she habitual?
Yes, a habitual second offense.
Okay, what's your offer?
The offer in this case, Your Honor, this is what I explained to the defendant also, is that there was a no reduced plea on this initially, and that the supervisors were asking for a mitigation package. Given the history of this case, there was no mitigation package that was submitted. The only thing that I could do at this point would be to ask the supervisors to consider something without the mitigation package and explain the history of the case and whatnot on my own. But I don't, in my conversations with the defendant, I don't know that is, I don't know where that would get us.
Okay. And what are you going to be recommending if you, if she were found guilty at the time of trial?
Your Honor, it depends, but I would say somewhere in the realm of 2 years in the Michigan Department of Corrections, up to with a tail of 7.5 years with the habitual.
And ma'am, the court is no longer bound by sentencing guidelines. I could give you a sentence less than the sentencing guidelines. I could give you a sentence within the sentencing guidelines, or I could give even more than 28 months, which is 2 years and 4 months. Understanding that, would you like to talk with your attorney about seeing if you can get some type of an offer that you'd be agreeable to, or do you want to go ahead to a jury trial?
I tried to find out what the offer was. She said she didn't have one.
All right. What kind of offer are you looking for me?
I really want a dismissal, but the
Okay,
only
Not
offer
getting a
that,
dismissal, we're beyond that, so.
okay, I get that.
Okay,
Well, the only offer I can see is because I'm not a habitual. I've never been in trouble with them.
she said you're a habitual second.
I never had a gun charge. I've never
Well, I
had.
don't know about a gun, but a felony conviction?
It's, December
She's a
13th.
Habitual second, what is it?
December 13th, 2013, fleeing and eluding in the 3rd degree in Calhoun County. It says that, you were convicted.
How does Calhoun County have anything to do with Wayne County?
State of
It's
Michigan.
the state of Michigan. Okay, well, that charge was dropped, correct?
Well, it sounds like you were found guilty of something. You must either pled or had a jury
I was
trial.
dropped. That charge got dropped. From my recollections, that charge was dropped.
Well, they're saying that it's not.
Okay.
So anyway, tell me what, if anything, you want the prosecutor to go and see about getting. What type of offer would you be willing to take, ma'am?
If anything, probation,
Okay. All right, let me talk.
no
to
jail
both of you.
time,
I'm sorry?
no jail time and probation. I'm sorry.
All right, let me talk to both the attorneys.
I do have
okay?
8 children.
I'm sorry, what?
I'm sorry. I do have 8 children and I've been away from them already 7 months.
All right, so let me talk to both of the attorneys.